Welcome to another episode of Legally Speaking with Rest the Case, where we decode legal complexities for the real world. Today, we're diving into a topic that's critical for businesses, investors, and legal professionals operating across borders: international arbitration and the enforcement of arbitral awards. Winning an award in arbitration is one thing, but getting it enforced in another country, that's where the real game begins. From the New York Convention to issues like public policy, natural justice, and the role of local courts, enforcement is where international arbitration meets its biggest challenges. To help us unpack this, we are joined by Advocate Sidhartha, an expert arbitration lawyer with years of experience in cross border dispute resolution. He'll walk us through how enforcement works, what can go wrong, and what parties should do to safeguard their rights long before a dispute even arises. So, if you're a founder, legal enthusiast, or a student curious about global legal frameworks, this episode is packed with insights you won't want to miss. So, Advocate Das, what is international arbitration and how does it differ from domestic arbitration?
Okay. International arbitration is nothing but a private dispute resolution process. Arbitration is normally a private dispute resolution process. So, international arbitration is nothing also but a private dispute resolution process where the parties, the dispute or the arbitration seat, the venue or the even the venue also sometimes spans across multiple countries. The key traits, if I am speaking of the key traits of international arbitration, it's one is neutrality. It's often held in a third country venue under agreed arbitral rules, agreed upon rules, maybe ICC, International Chamber of Commerce rules, maybe LIAC, maybe SIAC. LIAC is London International Arbitration Center, SIAC is Singapore International Arbitration Center, or DIAC. There are so many arbitration centers. Another key trait would be cross-border enforcement. These awards are enforced globally on the New York Convention. Second is the flexible procedure that it allows. The parties can choose the language, parties can choose the governing law and the procedural rules. So now coming, you asked about how it differs from domestic arbitration. Domestic arbitration, it's a private dispute resolution process. Normally, it can be held by an ad hoc arbitrator or an arbitral tribunal having three arbitrators, but it is confined to one country where all the parties and the seat are within the same jurisdictions. Okay, so some of the key traits or some of the characteristics of domestic arbitration normally includes local rules and codes governed by the national arbitration laws. Then the enforcement hours are enforced under the country's domestic legal network. For India, it would be Arbitration and Conciliation Act 1996. And the family procedures and laws are aligned with local practice and judicial oversight. So this is the best, what I think this is the best difference between international arbitration, wherein you have a much broader concept. Here, you are restricted to your country's own legal procedures.
And why do businesses and investors prefer arbitration over traditional court litigation when it comes to cross-border disputes?
See, Arbitration Act, when it came into existence, mm, uh, it provided a dispute resolution process out of the court, wherein a particular arbitrator acts as a private judge, and the time frame fixed for that was quite less than the court mandated procedures. So over here, so why they prefer is first and foremost they get a neutral forum, because once an arbitrator is appointed or arbitrator is about to be appointed, he has to give in writing like if he is a neutral or not, like if he has worked for any of the parties or not, like what his experience, everything he has to give. So they and the parties are at liberty to pick a neutral seat, avoiding the home court bias. Okay, then the enforceability hours are widely enforceable under the, as I told you, under the 1958 New York Convention. Okay, flexibility, the procedures, the language, the rules are tailored to the dispute's needs. Then there will be expert decision makers. panelists chosen for subject matter expertise. Okay. Then confidentiality, proceedings and outcomes remain private. Efficiency, streamlined timelines, and limited appeals can reduce these delays. Okay, so these are some of the things why they prefer arbitration over traditional court litigation.
All right. And can you briefly walk us through how international arbitration process typically works?
Okay, there are 6, 7 steps, like how it goes, how it functions, in fact. So the first one would be the arbitration agreement. Okay, there has to be an arbitration clause in an agreement. Then there will be constituting the tribunal. Okay, then there will be case management conferences, which also happens during a domestic arbitration also. So there is a case management conference. Then there will be pleadings and evidences which will be given by both the parties. And then there will be hearings. Then there will be an award, and then there will be enforcement. This is the process which goes through. Now, if I talk of the arbitration agreement, uh, the parties have to include an arbitration clause in their contract or sign a separate. If there is no arbitration clause in the contract, they have to submit to the, let's say I submit to the International Chamber of Commerce, ICC tribunal. So we have to sign a separate agreement specifying the rules, seat, and the language. If there is a contract between me and a third party who is residing abroad, and I want to, or who has a company abroad, seated abroad, so I have to basically, and there is no arbitration clause in the agreement. So I want it to go for arbitration. So I can go to a particular arbitral tribunal, and then I can file and sign a separate agreement for the arbitration. Then each party over here, there will be 3 arbitrators since it will be an arbitral tribunal. So each party will appoint 1 arbitrator, and those 2 will then choose the presiding arbitrator. Okay, or maybe where there is a where there is a conflict between choosing of 2 arbitrators, the institution can choose all the 3 arbitrators. Then the tribunal says the procedure, timetable, document exchange, witnesses who are to come, the lists of witnesses, confidentiality, and hearing dates. Then parties submit statements of claim, statement of defense, procedure, documentary evidence, exchange expert reports. Then live or virtual hearing is applicable here. It's also available in domestic arbitration for witness and expert testimony, cross-examination, and oral arguments. Then, as I told you, it comes to award. So the tribunal deliberates and issues a rescind award, which is final and binding, subject only to very limited challenges. Okay, if the award is, if you find out like this arbitrator has one of the arbitrators had worked for some one of the parties, so where it is perverse, only then you can challenge, and then successful party enforces the award in the jurisdiction. Party in the jurisdiction who are parties to the New York Convention.
Okay. And what makes an arbitral award enforceable? Are all awards automatically enforceable?
Arbitral award, in my opinion, I don't think they are automatically enforceable.
Okay.
There are some conditions which has to be satisfied. If you see, there are some conditions which has to be satisfied. That is, finality at the seat. The award must be final and binding under the law of the seat of the arbitration, because the seat actually defines which law, according to which law this arbitration is to be held. It's not the venue, it's the seat which the law where the seat is there. This means any local challenges or set aside applications at the supervisory court have been resolved, or the time for bringing them has expired. Okay. Then the tribunal's jurisdiction, this must be satisfied. It basically says the tribunal must have been properly constituted in accordance with the parties' arbitration agreement. If one party can show that an arbitrator lacked authority because the agreement was invalid or the tribunal exceeded its mandate, that can block the enforcement. Then due process compliance, both parties must have received proper notice of the proceedings and fully opportunity to present evidence and argument. Any denial of these basic procedural rights, such as proceeding ex parte or refusing to admit key testimony, can render the award unenforceable. Then most jurisdictions, that is the documentary requirements, formal and documentary requirements. Most jurisdictions require the award and the arbitration agreement to be properly authenticated and were not in an official language accompanied by certified translations. Some statutes also impose strict timelines for filing the award in the court. Then absence of set aside or refusal grounds. Even once final, these national courts may still refuse enforcement on narrow grounds such as violation of public policy award beyond the scope of the arbitration clause, or serious irregularity in the tribunal's conduct. Only when all these criteria are met can a successful party obtain an enforcement order and proceed to attach or seize the assets of the respondent's jurisdiction.
Okay. And so what role does New York Convention play in enforcement of international arbitral awards?
See, New York Convention is the baseline where all the arbitrations, even domestic or even Indian, if you see Indian Arbitration Act, it also follows this New York Convention to quite a lot of extent. Okay, so these contracting states, any of the contracting states under the New York Convention, they undertake three core obligations. Uh, that coming together, they create a powerful enforcement network. First is the scope and reciprocity. That is Article 1 of the New York Convention. That it has got a broad scope and reciprocity. Okay, then it has mandatory recognition and enforcement, Article 2, and then it has a streamlined exequatur. It has a streamlined exequatur with limited defenses. That is Article 5. So this is how this New York Convention play. What I mean by a streamlined exequatur is that enforcement, as I told you earlier, can be refused only on narrowly defined grounds. If they oppose the public policy, or there is an invalid arbitration clause in the agreement, lack of due process, that is not giving a notice, and all this stuff. And then the New York Convention provides uniform efficiency-driven procedure for this year by harmonizing national equator processes requiring only authenticated award copies and certified translations in many states. This convention, New York Convention, eliminates onerous local hurdles and accelerates cross-border enforcement. So together, this provision transforms the convention into a near universal treaty that underpins the enforceability of international arbitral awards, giving the parties the confidence to resolve disputes outside domestic courts.
Okay. And one of the most influential cases in international arbitration enforcement is Renusagar Power Co. Limited versus General Electric Company,
Yes.
1994, where the Supreme Court of India narrowly interpreted public policy to support enforcement. Can you explain how this landmark judgment shaped the enforcement framework in India, and why is it still kind of referred to in discussions about arbitral awards, foreign arbitral awards?
See, Renusagar, as far as I have read Renusagar, just give me 1 second. Let me just recap it. Renusagar, I think uh, public policy exception. It was a public policy exception under Section 48(2).
Hmm.
48 subsection 2. I don't remember the other subsections. So under Section 48(2), but the Supreme Court held it must be interpreted narrowly. It also held that mere errors of law, harsh or unexpected outcomes or breaches of Indian law do not offend public policy. They said that does not offend public policy. Only awards that contravene the fundamental policy of Indian law, the interests of India, notions of justice and morality can be refused enforcement. However, there was this ONGC and SAW pipes. In 2003, the Supreme Court introduced the additional ground of patent illegality as falling within the public policy. And under this particular year, if I remember, an award may be considered patently illegal and thus contrary to public policy if it contravenes the substantive provisions of Indian law, that is, it exceeds the statutory limits, violates the terms of the parties' contract in a way that is blatant on the face of the award. So these are the two things that they held. So Here, Renusagar had a narrow, as you said, it had the public policy, the exception, public policy exception was narrow, but it was consequently enlarged, widened in ONGC. So Indian courts continue to emphasize on minimal judicial intervention because of this widening in the ONGC case. They will not re-examine the merits of the dispute or correct errors of fact or law outside the narrow patent illegality threshold. Moreover, High Courts routinely underscores India's obligations under the New York Convention to process exequatur applications quickly, refusing enforcement only on grounds expressly set out in Section 48 of the Indian Arbitration and Conciliation Act, and giving parties confidence in India as a pro-enforcement jurisdiction. So basically, Renusagar was, you can say, to an extent, it was the public policy by introducing patent illegality. The public policy scope was widened in ONGC.
Okay. Okay, got it. And when it comes to enforcing foreign arbitral awards, what are the key requirements under the Indian law?
Enforcing foreign arbitral awards. Uh,
So, what would be the key requirements under the Indian law for enforcing a foreign arbitral award?
uh, Enforcing a foreign arbitral award. Just give me 1 second.
Yeah.
Okay. For enforcing foreign arbitral awards uh, in India, this okay. If we see the part two of the India's Arbitration and Conciliation Act, that is which gives effect to the NYC. A foreign award is enforceable in India only if it was rendered in a convention state or in India, that is the seat or origin. It has a valid arbitration agreement. Under Section 47, you file the original award or a certified copy, the arbitration agreement, and if any document is not in English or Hindi, certified Hindi or English translations, and the award does not offend any of the limited refusal grounds, that is Section 48 as we discussed earlier, and there is a timely application. So these are the main things which normally, you know, answers your question, the key requirements under Indian law for enforcing a foreign arbitral award.
Okay. And what would be the key difference between recognition and enforcement of an award? Are they always granted together?
Uh, See, granting together is something different. First, you have to understand what is recognition, what is enforcement.
Hmm.
Recognition is something I recognize you
Hmm.
because I've been discussing with you, so I recognize you. Similarly, the concept here says recognition is the court's formal acknowledgement that a foreign or domestic award is valid and binding within its jurisdiction. Okay, once recognized, the award has the same legal status as a domestic judgment, but no execution follows automatically. Okay, so enforcement is the court's grant of coercive remedies in the order, such as attachment of bank accounts, garnishment of receivables, or sale of assets, to give effect to the award. Only after enforcement is ordered can a successful party actually recover on the award.
Right.
Okay, so here recognition means the court understands, the court takes into consideration that this award is the formal acknowledgement. This award gives a formal acknowledgement that this award, but this foreign award is valid and is binding within its jurisdiction.
Hmm. All right. So I'm just going to skip a few of the questions here. I mean, we've already kind of discussed that in detail. So I would also like to ask, how does the location or the seat of arbitration affect enforcement rights?
It determines the lex act,
Hmm.
that is the law which will apply to the arbitration proceedings.
Right.
Okay, which frames the critical aspects such as court intervention, admissibility of evidence, and availability of interim relief. Under the unilateral model, uh, Article 20, I don't remember the subsection, Article 20 confirms that the seat need not coincide with the physical location of the hearings, that is the venue. It's a juridical concept chosen by the parties. Courts at the seat retain supervisory jurisdiction to grant emergency measures, assist with document production, and hear challenges to the award. That is either setting aside or annulling the award. Selecting a seat renowned for arbitration-friendly jurisprudence, maybe Singapore, London, Dubai, Paris, can significantly reduce the risk of annulment and streamline later recognition and enforcement of the award.
Right. And when it comes to companies, what should they consider when drafting arbitration clauses in cross-border contracts?
They should specify a neutral pro-enforcement seat. Maybe let's say Singapore, for example, or Dubai. Dubai is coming up right now, so Dubai. Incorporate the institutional rules. Maybe which rules do they follow? ICC,
Hmm.
DISC, SISC, LCA, London Institute of Arbitration. That means that provides a clear appointment process and case management approach. Then the states, they should include the states, the governing law and the arbitration language, because that will avoid the jurisdictional ambiguity. Then they should provide for interim measures, either under the institutional emergency arbitrator provisions or national court relief. Then limits should limit appeal by clarifying that the award is final and binding, subject only to the narrow review grounds under the seats law. So this will do away with the unnecessary applications in the courts for annulment or setting aside the order. Okay, so until unless the order is perverse, as I said, should be narrow ground. So taking India as one of the, Indian company as one of the parties. So the narrow ground is defined in section 48. So naturally, if that is there, then they can go for 34 or 37 applications.
Right.
So this should be there in the arbitration clause.
Okay. And are there any reforms or developments you hope to see in international arbitration enforcement?
Uh, Repeat your question.
Are there any reforms or developments you hope to see in international arbitration enforcement?
Yes. Some of the desired informations is unified public policy test. Today, public policy means different things in different jurisdictions.
Hmm.
India has limited it to fundamental morality and justice, while others stretch it to encompass broad statutory or economic reforms. So an updated unilateral model law provision would set clear uniform criteria, maybe corruption, fraud, fundamental procedural unfairness, and explicitly exclude mere errors of law or harsh results. So this will eliminate forum shopping for expensive public policy defenses, reduce time and cost spent litigating, increase predicability, giving parties greater confidence. Then cross-border e-discovery frameworks. Unlike many civil law jurisdictions, common law systems routinely allow broad pre-hearing document production. Now, this mismatch often hampers evidence gathering in cross-border disputes. So, a standard e-discovery protocol would help harmonize rules and scope, enable simultaneous track document sharing, support AI-driven document review tools, speeding analysis while preserving data security. Then there should be enhanced appointment transparency. Party-appointed arbitrators today disclose conflicts according to valid institutional guidelines, but transparency remains uneven. A reform package, as per I think it should be a mandatory publication of all past and present affiliations, an agreed rotation mechanism to avoid repeat appointment by the same parties, and a centralized searchable registry of arbitrator backgrounds and performance metrics. So these are some things which I think can be improvised.
Hmm.
But still, we are doing a lot, and arbitration is still on the rise.
Yeah, right, right. And my final question to you then would be, for young lawyers or law students who are interested in arbitration, what parts or skills would you recommend for them?
They can get specialized credentials like CIR. Okay, and then they can have certification of SCIA, LCIA, or DISE. Okay, and they can have practical experiences like internships and secondments, moot competition and clinics, and they can have core skill developments like drafting and advocacy, cross-cultural negotiation, language proficiency. Beyond English, you can start learning some other language. For example, maybe German, or maybe French, or maybe for that example, if I'm talking of SISC, then the regional language of Singapore. So by combining, certified training, especially by step progression, with hands-on internships, moods, and targeted skill workshop, I think they can build the expertise and network essential for a thriving international arbitration career.
All right. I think with that, we wrap up today's insightful conversation with Advocate Siddharthas on the enforcement of international arbitral awards. And as we've heard today, enforcement isn't just a legal formality, it's the bedrock that gives arbitration its global credibility. From carefully choosing the seat of the arbitration to drafting enforceable clauses and understanding evolving court trends, there's a lot at stake. Whether you're entering cross border contracts or building a career in dispute resolution, the key takeaway is clear: prevention and precision beat panic every time. A huge thank you to you, Advocate Siddharthas, for sharing your expertise with us. And make sure you follow Rest the Case for more episodes where we simplify the law one conversation at a time. Until next time, stay informed and stay safe. Thank you so much.
Thank you.